Once you've signed, you're really not done. The next step is you have to title things correctly and you have to fund your trust.
Some families, personally, create individual trusts. So I have my trust and my spouse has his trust, and then that's how we title things. It could be just preference, right? But that was our preference. If you have a spouse, you would like to transfer 100% beneficiary to your spouse because you avoid inherited IRAs or Roth IRAs. Hello and welcome to Express Yourself Podcast. I'm your host, Vanessa Martinez, and today I have Lauren Gennardi with me. She is a partner here at Expressive Wealth and also a wealth advisor. And I have Steph Morowski. She's an attorney and also a wealth advisor with us here at Expressive Wealth. So typically on our podcast, we do Q&A. We send out questions or we receive questions and we try to answer these topics that are enticing to everyone. But today, or I should say, whenever we have Steph join us, we like to talk topics that kind of intersect law and finance. So today, Steph is going to kick us off on our topic.
Well, today we are going to be looking at some top estate planning misses, if you will. So this is kind of going to be a two-part podcast. And today we're going to talk primarily the low-hanging fruit, the really easy to accomplish misses that, you can correct. And then next week, we will look into, get a little bit more into the estate planning weeds and make sure that all of those boxes are checked. But today it's really high level. So first we're going to talk through, the myths of making a trust and not funding it, having outdated estate planning and beneficiary designation documents, and then creating consistency across your entire estate plan. So with the first topic, this is one we see often where folks are so excited that they've done all the hard work and created a beautiful trust and there's nothing in it.
Absolutely. And I think it's a step that sometimes people forget. It's like out of sight is out of mind. I did it. I talked to the attorney. I made the document. I'm done. You're not really done. Now you actually have to follow the instructions from your attorney in terms of funding your trust. So I had a experience in my career with prior client where she had done a trust many, many years ago. And she was in a second marriage and the husband did not know that she had done a trust. And she forgot that she had done a trust. And what happens? She had a very sudden and unexpected death. And what ended up happening was then the husband found her documents buried in a drawer somewhere, but we had accounts that were never titled into the name of the trust. So all the assets went through probate because that simple step was missed. So that's a really important piece. Once you've signed, you're really not done. The next step is you have to title things correctly and you have to fund your trust.
Sorry, Steph. I think there's also the side of it depends on how your family creates the estate, right? So some families create a family trust. So it's one title for both parties to add to their bank accounts and to all the other assets, right? Real estate or anything else that they have. Some families, personally, create individual trusts. So I have my trust and my spouse has his trust, and then that's how we title things. Even if the trusts say similar things, maybe there's a difference that I have in mine or he might have in his, and that's why we establish them that way. And it could be just preference, right? But that was our preference. But then what is really important as time goes on and your wealth continues to accumulate is each state also has a maximum that you need to then decide what other things you're going to do with it before taxes hit. So it's kind of, let's make sure each trust has equal parts in it. So then when you inherit it onto the kids. But that could be something that it's typically the main breadwinner might say, oh, that's fine. The trusts say the same thing. So we could just keep it in one trust for now. So this is also another way to say, okay, this is an unfunded trust. You funded one, but did you fund the other one?
Absolutely. And you're piquing my interest in maybe a part 3. Maybe down the line, we'll need to talk about the merits of individual trusts versus a family trust, because there's
Right.
a lot to that as well. So number two on our list today, outdated documents. So this comes up in a number of ways, oftentimes through, generally you're looking at needing to update documents after a major life event, a remarriage, a death, a new birth, that type of thing. But another reason that we like clients to redress this is because of the policy changes that have occurred at a federal level in recent years due to the Secure Act.
Yes. The Secure Act was approved, the Secure Act 2.0 was approved late December of 2022. So as of January of 2023, the implementation of these rules came about. Now, there's many, many aspects in the Secure Act, but one that ties specifically to trusts is the policy on retirement accounts. So typically, if you have a spouse, you would like to transfer 100% beneficiary to your spouse because you avoid inherited IRAs or Roth IRAs. So it's easy. You say, here you go, husband, wife, partner, you take all of my assets. Easy, no taxes, no nothing, no additional rules. It's taken as if it was theirs from the beginning. The issue then comes about where if you say, oh, I'd like to assign my trust as the beneficiary of my retirement accounts, which you may do so. And in the past, that was much easier. You just assign it and it would follow the rules of the trust and inherit as you set your provisions in your document. But as of January of 2023, the new rule came into play where you have 10 years to take the distributions out of your inherited retirement account. So you must take it out in 10 years.
Right.
You can also accumulate it to the year 10 and then take it all out. But you have 10 years to do it. You can equally split them. You can do bulks, whatever you want. But by 10 years, it's got to be done. So that now requires, if you'd like to have your trust be the beneficiary, it must be one of two additional provisions that you add to your document. It has to be either a conduit trust or an accumulation trust. So as Steph was stating before, typically you're like, well, nothing in life has changed. No one has passed away. Kids are fine. Everything's normal. Why am I going to sit there, go back to an attorney and have to review everything all over again? Because the law is changing. And if the law is changing, that means there's other stipulations and consequences on what can be done and when things need to be taken out. So in the end, happens. It's all about taxes. So make sure that if you do have a trust and you haven't had it reviewed and it was drafted before Secure Act 2.0, so before 2022, if you've had it drafted then, it's definitely time for a review to make sure it's up to date with the new provisions that came out.
Absolutely. And number three for today, we always recommend that there is consistency in your estate plan as a general rule. So your will may not be the controlling document for all of your, wishes should you pass. Things such as, jointly titled accounts or beneficiary designations will be the controlling document. So, you need to make sure that when you're kind of thinking this on the front end, when you're titling initial accounts and on the beneficiary side, that those beneficiaries are up to date and that, at a minimum, once a year, you've got a reminder on your phone, you get that notification. Make sure that those documents still reflect the beneficiaries that you intend and are, up to date. And things can go wrong when those aren't kept current.
Right. Mistakes happen, right? We all aim to be consistent, and you've worked with an attorney and you've made the plan and you've done the things, but sometimes things get missed. And this is why it's good to have a second set of eyes on your documents and your beneficiary designations at times. I know someone who went through after her spouse had passed away and she updated her estate plan, as you should, right? We talked about major life events. She updated her estate plan, went, updated beneficiaries designations on her retirement accounts, and then she got ill and she passed away. And what happened? After she passed away, we found that there was one account that she missed, that she forgot to retitle. It was still the beneficiary was the deceased husband. And now here you go, you have an asset that's going through probate that was never intended to go through probate. So accidents happen. This is really why get a second set of eyes. Not the time to be secretive. Show your advisors, show your attorneys, ask for people to double check to make sure everything is just really nicely buttoned up.
Yeah, and that's a great reason why, even if you don't have your advisor managing every account that you have, and that often is the case, they at least know what all comprises your estate. Because then, like you said, the second set of eyes is crucial in just flagging things on an ongoing basis. Have we looked at this account? Are all the beneficiary designations up to date and current with your wishes? And is everything kind of going to reflect what should some unfortunate event arise, what you desire?
I think you mentioned stuff that as we're talking, we think of other steps to add to this. So we'll
Yeah,
have the part two where we'll dig a little deeper on a couple other estate planning misses. But I also think from this conversation that we should have another one where it talks about will or trust,
yeah,
because that is
absolutely.
such a big question for many. And what do they mean? As Lauren just stated, the word probate. But wait, if I have a trust, then why did that happen? So I think it's really important to talk about that topic. So we'll make sure we share with everyone what that means and how that works on on another podcast that we'll share.
And stay
Thank you so
tuned for
much.
part two.
Yes. Thank you everyone for listening.
Thank you.